Sorry, didn't mean to take that seat for everybody. Okay, we'll continue, Mr. Cox, and we had discussed about we getting to repeat, and we're ready. I think I'd get 7 votes to say it's time to move on. We've been doing this about an hour and 15 minutes, so time to wrap this up.
Mr. Chairman, I'd ask that the last email that we were looking at, dated July 14th, 2016, be entered as the next hearing exhibit.
163, it will be entered as hearing exhibit 163.
Mr. Byrne, isn't it true that Westinghouse was also failing to live up to its obligations by not agreeing to provide a true-up at the end of the interim period in the fall of 2016?
It was the position of the owners that true-up was required. Westinghouse had adopted a position that the true-up was not required. That position was taken to a dispute resolution board, and that dispute resolution board sided with Westinghouse. And
it was the owner's position that Westinghouse should have provided a true-up, correct?
That's correct.
And to your left there on the table in front of you, there's a document that's entitled Order. And this is a document produced by SC&G. I believe it's the order you're referring to, dated September 30th, 2016. Is that correct?
It says order. Did you describe this as an SC&G document?
It was it was produced by SC&G in this litigation. If you turn to the third page of the document, if you go to paragraph 9 on page 3, the first sentence says the board also finds that payments made by owner to contractor pursuant to paragraphs 3 and 12 of the October 15 amendment shall not be subject to true-up. This is the order you're referring to, is that correct?
It was the order that I referred to. You referred to this as an SC&G document. It was not. This was prepared by the DRB.
I understand. Mr. Chairman, I'd ask that this document be entered as the next hearing exhibit.
It will be entered as exhibit number 164.
And I think we covered this earlier, Mr. Byrne, but it was over $200 million that SC&G believed that it was owed at this time in true-up funds. Is that correct?
I think what I said earlier was I don't recall what the number was.
I'd like you to take a look at the other document that's next to you to your left. It's a document entitled Owner's Statement of Issues Remaining and Position on Those Issues. This is a document that SC&G provided to ORS in this litigation, and it's an 11-page document that's signed by George Winnick, and it's before the DRB. Was George Winnick the attorney for SC&G in the DRB dispute?
He was the attorney for the owners in the DRB dispute, yes.
Mr. Chairman, at this time I'd ask that this document be entered as the next hearing exhibit.
It will be entered as exhibit 165.
I'd like for you to turn, Mr. Byrne, to the top of page 5 of this document. And Mr. Winnick in this document is referring to the past true-up that SC&G and the owners believed that they were owed under the 2015 amendment. And then he also adds in the amount that he believes under the DRB order that SC&G would be owed if the next 2 months of invoices are included. And isn't it true that Mr. Winnick at this time estimated that the overpayment that the owners would have made to Westinghouse at the end of the October time frame is $373.9 million?
Yeah, I think what Mr. Winnick is doing is he's taking the payments that had been ordered by the DRB to be made and extrapolating that out to what the overpayment would be.
And if you turn now lower on that page 5 to the last complete paragraph, I'd like to read the second and third sentences in that paragraph. Quote, if the contractor completes the project for the fixed price against all probability, then the DRB's ruling will have done little harm. On the other hand, if the contractor declares a strategic bankruptcy and leaves the owner without sufficient funds to complete the project, as seems more likely, then the last thing on the owner's mind will be the DRB's role in allowing that to happen. End quote. Did I read that correctly, Mr. Byrne?
You appear to have read that correctly.
And this document is dated November 3rd, 2016. Is that correct?
Yes, that's correct.
Now, turning to the order itself, Exhibit 164, Mr. Byrne, did you become aware of that order on the day it was issued?
I don't remember.
Do you recall whether you became notified of it within a day or two of it being issued?
I don't remember the time frame around the order and when I was notified of it.
Now, it's true, Mr. Byrne, that no one at SC&G notified the commission in the October 2016 hearing about this order that was rejecting the owner's request for true-ups, correct?
I don't recall what the timing was relative to this order when the testimony was given. So I don't know if this was discussed or not discussed, and I don't recall what the timing was of the hearing and of this order.
I'd like to show some of your testimony from the 2016 hearing, which occurred on October 12, 2016. And this is page 592 of the transcript. And this is questioning of you done by Mr. Guile, present here. The question to you is, all right, you signed a contract in October. Couldn't work it out with Westinghouse between October and August. August, you finally said, we got to go to the DRB with this particular dispute, correct? Answer, right. We filed with the Dispute Resolution Board in August, and the dispute was heard by the Dispute Resolution Board end of September, 1st of October. And when you say heard, they had a trial-type proceeding. Yes. All right, how long did that take? It took 3 days. Were you a participant? Answer, I did. Question, all right. Heard testimony? Correct. Question, got lots of paperwork, exhibits? Answer, not as much as in these proceedings. But yes. Okay, and under oath, testimony under oath? It was under oath. And was the matter transcribed? There was a court reporter. Okay, good. And so they heard 3 days of litigation about this, these 3 lawyers, and what are they doing about it now? It's sort of a similar process where they get proposed orders and they've told us they'll render their decision by the end of November. Question, okay, so you submitted proposed orders and the Westinghouse folks have done likewise? Answer, correct. And it's now pending their decision. Answer, correct. Question, end of November, you say? I think that's the time frame, end of November. Did I read that correctly, Mr. Byrne?
You appear to have read it correctly.
So it's correct to say that in that exchange you had with Mr. Guile, you did not reveal the order that the DRB had issued 2 weeks prior, in which hundreds of millions of dollars that the owners were expecting to be returned to them through a true-up mechanism was rejected by the DRB.
I don't know that I knew about this order at the time of the hearing.
When you expect an order of this magnitude, you probably would have learned about it within a day or two of it being issued?
Yeah, as I said, I don't know that I knew about this order at the time of the hearing.
Well, I received an email produced by Santee Cooper in which Mr. Winnick forwarded the order to both the attorneys for SC&G and Santee Cooper on the day the order was issued. That document was produced by Santee Cooper. It was not produced by SC&G in this litigation, so I can't specifically confirm that you received it. However, there is another document. Have you done a president's briefing before, Mr. Byrne?
Have I done a president's briefing?
A president's report?
President's report, yes.
And you would do that quarterly, is that correct?
Yes, roughly quarterly.
And let's strike that. Now, that 2016 proceeding, Mr. Byrne, that ended in a settlement, correct?
You talking about the DRB proceeding?
I'm sorry, the 2016 PSC proceeding.
There was a settlement agreement and there was a hearing.
And SC&G agreed to protect the ratepayers with the fixed price option, even if Westinghouse did not honor it. Isn't that right?
I don't recall that to be the case. I don't know.
It's true that SC&G didn't honor its promise to the Commission and the ratepayers to complete the project for the fixed price option if Westinghouse didn't complete the project.
The premise of your question is that SC&G made a promise, and I don't know that to be the case.
Okay. I'd like to turn now to the Bechtel issue, Mr. Byrne. You talked on the phone with Ty Troutman, the president of Bechtel, after the October 2015 Bechtel presentation, didn't you?
I believe I spoke to him one time in December.
And you told him that you thought the October 2015 Bechtel presentation was enough and that a written report was not needed, didn't you?
You may be paraphrasing what I said. I believe Mr. Troutman asked what I thought the next steps would be, and I simply rendered an opinion that as far as I was concerned, it was done. The presentation was it.
And no written report was needed, correct?
I don't recall saying that, but certainly that's what I would have implied by saying that the October presentation was it.
And isn't it true, Mr. Byrne, that between the time of the October 2015 presentation and the issuance of the final Bechtel report, you talked to the lawyer Winnick about getting the schedule assessment removed from the Bechtel report?
No.
Mr. Chairman, I've sat here for the last couple of days and listened to Mr. Cox and Mr. Richardson refer to George Winnick as lawyer Winnick, and I would ask that Mr. Cox accord Mr. Winnick the same respect he accords the other lawyers in this room by referring to him as Mr. Winnick as opposed to lawyer Winnick. He doesn't refer to his colleagues here as lawyer Guild or lawyer Elliott, and I ask that he treat Mr. Winnick with the same respect he accords others.
Call me that any time, Mr. Chairman. I like the term.
Okay. Yeah. Okay. Let's all be sensitive here.
Understood, Mr. Chairman. I understood, Mr. Balzer.
Mr. Guy will do that sometime.
It's sort of a mark of honor, Your Honor.
Now, Mr. Byrne, in your summary regarding your testimony summary today, you said that you don't recall receiving the November draft Bechtel presentation. Is that correct?
That's correct.
So you're not saying you didn't receive it. You're saying you don't recall receiving it, right?
I'm saying that I don't, to the best of my recollection, I don't believe I received that report.
Okay. Why'd you use the word recall? Is that something that you feel that there's some doubt in your mind?
I don't think any of us are perfect, but to the best of my recollection, I did not receive that report. I didn't see it until after the project was canceled.
And it's your testimony that you never talked to Mr. Winnick about edits to that report?
I did not.
Isn't it true that Mr. Troutman talked to you about his displeasure about Mr. Winnick's edits to the draft Bechtel report?
Mr. Troutman, from what I remember, did talk about the fact that Mr. Winnick had made some comments on the report.
And he was unhappy with those, correct?
I believe that's accurate.
And that's because Bechtel disagreed with removing the most important part of the Bechtel assessment, correct?
I don't know that to be the case.
Isn't it true that your partner, Santee Cooper, was asking your help in trying to obtain a copy of the Bechtel report from Mr. Winnick, but you wouldn't help them, right?
I don't know that that's the case.
I'd like to show you an email. It's part of the Elizabeth Warner exhibit A16. It's an email between you and Mr. Crosby. It's a one-page email. And the email begins, it's from Mr. Crosby to you. It says, Steve, hope all is well in D.C. I'm still operating out of Florida, but hoping to be wrapping things up here soon, on target for the end of the month. Do you know the status of the Bechtel doc? As discussed last Thursday, Energy Room, our board meeting is Monday the 25th. Anything you can do to help free up that doc would be greatly appreciated. And then you respond that same day. You say, Michael, not sure on duration for Carlette. We can discuss next time we are together. I am not sure of the outcome of the lawyer's discussion on the Bechtel report. Let me check with Ron Lindsay. So isn't it true at this time, Mr. Byrne, that Santee Cooper had asked for your help trying to free up a copy of the Bechtel report?
When I said Bechtel report here, what I was referring to was the presentation that Bechtel gave in October of 2015. Mr. Crosby seemed to be asking for my help on something that the lawyers were dealing with. So it was really not my place to do anything with the report.
Well, you're the one that refers to the Bechtel report here, correct, Mr.
Correct.
So what were you talking about?
I just said what I was talking about.
What was that?
It was the October 22nd of 2015 presentation.
Isn't it true, Mr. Byrne, that SC&G attempted to hire the Bechtel employee who performed the schedule assessment to do more work on the project a few months after the Bechtel assessment ended?
It is true that Mr. Archie attempted to hire a gentleman from Bechtel called Jason Williams to help on schedule. I believe that was with the construction milestone payment schedule that the owners were trying to negotiate with Westinghouse.
And the employee's name was Jason Moore, correct?
I think so.
And isn't it true that you tried to hire him both directly and through Bechtel?
I didn't try to do it. Mr. Archie attempted to do that. And what Mr. Archie said to me was that Mr. Moore was going to have to check with his higher-ups at Bechtel, and then came back and told me that they said no.
And you told Mr. Archie to pursue that option, didn't you?
He brought it to me, and I said I didn't have any problem with it.
Let's go and look at Exhibit 162, which we looked at earlier. This is your March 2016 email with Mr. Crosby. If you look at the email from you to Mr. Crosby, it says, quote, Jeff is working that. He contacted Jason, who is interested in helping. He sought permission to do it on a direct contract rather than Bechtel, but his management said no. I told Jeff to pursue anyway. We are also looking for someone else, likely from the TVA project, end quote. Did I read that correctly?
You did.
And isn't it true that SC&G also tracked its compliance with the recommendations made by Bechtel, didn't it?
After the final report was received and there were recommendations, the owners put together a team to evaluate the recommendations in the Bechtel report, yes.
And that document is Exhibit 25 to your deposition, isn't that right?
I don't recall.
Is this show it on the overhead here? This is Exhibit 25 to your deposition. Is this the document you're referring to?
That is at least a part of it. It may have been an earlier draft where Santee Cooper was commenting on it.
And Mr. Byrne, you spoke glowingly about the reputation and work of Bechtel in the 2008 docket before this commission, didn't you?
Bechtel was helping SCE&G or helping the owners with licensing. And so the licensing staff from Bechtel, I thought, did a good job in preparing the combined construction and operating license application.
I'd like to turn, Mr. Byrne, to the EAC team that was discussed as part of the 2015 docket. Isn't it true that in your pre-filed testimony in the 2015 docket that you pointed to the work done by the internal SCE&G cost and schedule teams as a reason that the request for modification of the schedules should be approved?
I don't specifically recall that, but that may be the case.
It's fair to say that you did not reveal in your 2015 testimony to the PSC the conclusions that were reached by the internal EAC team.
I don't know that I would characterize it that way. I believe that the conclusions reached by the EAC team were for negotiation purposes with the consortium. At that point in time, it was still a consortium, and that the consortium had given to the owners a fairly significant increase in both cost and schedule. And so there were two teams put together. One of them, the EAC team I believe you're talking about, is the cost team. And that cost team did run a number of scenarios. And one of the scenarios presented at a meeting with me was a scenario of if nothing changed, this is what the outcome would likely be from a cost perspective. So that was to aid that and all the other things that they were doing, looking at disallowances of cost, entitlement of costs, were to help the management with negotiation with the consortium.
Isn't it correct, Mr. Byrne, that both the ORS and the Commission relied on SC&G's representation of having reviewed the consortium's estimate as the basis for approving SC&G's petition in 2015?
Say that again?
Isn't it true that both the ORS and the Commission relied on SC&G's representation of having reviewed the information as the basis for approving SC&G's petition?
I can't say what the Commission or the ORS relied upon in making a decision. Certainly the company did present its basis for the schedule and cost in that petition.
Mr. Byrne, you mentioned earlier that you felt that Mr. Carter was negotiating in some of the emails he sent to you and Mr. Marsh. Is that correct?
Yes.
Did you feel that you and Santee Cooper, SC&G and Santee Cooper, had a relationship in which they needed to negotiate differences?
Did I feel that way? I didn't necessarily feel that way. I think that Santee Cooper may have felt a little differently about it. Partly, I think, because they were the minority owner and were not the ones that were running the construction at the facility.
Mr. Byrne, the last issue I'd like to cover with you, it's correct that SC&G performed an analysis of the cost and schedule that would likely occur to complete the project after Westinghouse's bankruptcy, right?
That's correct.
If I may, Mr. Chairman.
You said this was last issue, right?
Yes.
Because I'm at about my 2-hour cross limit.
The document that I've handed you, Mr. Byrne, this is a presentation that Mr. Marsh made to the Special Legislative Committee after the Westinghouse bankruptcy, correct?
That's what it appears, yes.
And it includes the analysis that SC&G did after the Westinghouse bankruptcy, correct?
Where are you reading from?
I'm reading from page 12. Page 11 and 12.
Page 11 and 12, project evaluation, yes.
So let's look at page 11, Mr. Byrne. So this report says that Westinghouse provided an estimate to complete construction of $1.5 billion over the fixed price contract in 2017. Is that correct?
That is what it says, yes.
And SC&G determined that the additional cost to complete was almost 3 times more than Westinghouse's estimate. Is that right?
Yes, that's correct.
And isn't it, so that's about a $3 billion difference, is that correct?
Hang on a second. Yeah, that would be about a $3 billion difference, correct.
And isn't it true that SC&G also determined that there would be about a 3-year delay in the completion date for the units versus the Westinghouse analysis?
What SC&G did was a new analysis in an owner-directed model, no longer in the EPC model, so that we're not comparing apples to apples here. So that would not be to infer that had construction continued under the EPC model with Westinghouse as the lead contractor, as a counterparty to an EPC, that their durations would have been the same as what SC&G had come up with or the owners had come up with.
But it's fair to say that SC&G determined that the completion would be 3 years later than what Westinghouse had concluded if SC&G decided to go forward.
Yeah, under a different model, under an owner-directed model, not wanting to assume some of the risks that Westinghouse would assume as a contractor. Yeah, it was a different model, and it was a different result.
And isn't it correct, Mr. Byrne, that over 2 years earlier, or about 2 years earlier, that Bechtel had determined that there was a 2-year delay in the scheduled completion versus what the consortium had indicated?
In October of 15, is that the one you're talking about?
Correct.
In October of 15, Bechtel did give a schedule assessment with a warning not to use it to rebaseline the schedule. And in the meeting where the presentation was given in October, I think it was October 22nd of 2015. I believe it was Carl Rao from Bechtel said that they would have to do a much deeper dive in order to get an accurate schedule reflection. And
you understood that Bechtel was not rebaselining the schedule in its assessment; it was assessing the schedule, correct?
My understanding of what Bechtel was to do was to assess the project. What they were doing in this effort appeared to be a schedule rebaseline, which I don't believe they had the information or the time to do.
Thank you, Mr. Byrne. I have no further questions. Thank you, Mr. Chairman.
Thank you, Mr. Cox. Further cross.
Mr. Chairman, no questions. Thank you.
Thank you, Mr. Gile. Commissioners. Commissioner Elam.
Good morning, Mr. Byrne.
Good morning.
Ken Brown testified yesterday in some detail of his methods for estimating SC&G's cost to completion, the EAC, and the EAC team's findings seem to have been rebuked whenever presented to management. Is that fair?
No, I wouldn't say that's fair. The EAC team that was commissioned by the owners was to take a look at the information that Westinghouse had presented. And just like in 2010 when 10 or 12% extra and the contract was converted from variable to fixed, and just like in 2012 when there were 4 big picture commercial items, including the delay in getting the license, were negotiated, this project was taking on a negotiating posture. And so we were always negotiating with the consortium. So the EAC team was tasked with reviewing the information to the extent that they could, that they get from Westinghouse, and looking for things that would help the negotiation team, of which I was a part, to negotiate with the consortium.
I was noticing in your summary on page 4, about halfway down, you described it as my understanding of the purpose of this analysis. You weren't clear on what the purpose was?
No, it's just that I have become aware that people have been saying that this analysis was to do this or to do that. You said that Mr. Brown talked about his method to evaluate the EAC. The team was not tasked with coming up with a new EAC. The team wouldn't have had the time or the resources in order to truly do that. But one of the inputs that they use, which I know has gotten some play, is that they used an existing performance factor and said, if we just assume that that's the to-go performance factor, this is what it'll show, and it was $101 million higher from what I remember from the presentation. So that was a data point. That's the risk to SC, E&G, or to the owners if performance does not improve. Now, Westinghouse is assuming improvements, but this was a negotiating point for people like me when I'm talking with my counterpart at Westinghouse and CB&I, because at the time it was still a consortium on this EAC. So
you knew up front what the purpose of the EAC was. As the chief nuclear officer, you know what the purpose of it was?
Yeah, Jeff Archie was the chief nuclear officer, but and the EAC team that reported up through Carlette Walker reported up through the CFO. So it didn't report up through my chain, but there was no doubt in my mind what the EAC team was there to do, and that was to arm the executives with negotiating points so we can get to a better outcome with Westinghouse.
So you were familiar with the EAC team's techniques for establishing cost and schedule estimates?
Yeah, they had the EAC team had covered with a number of the executives their presentation, and I think it was in October of 2014. So they covered with the executives what their premise was, what their basis for their EAC was.
And you didn't feel it was necessary to disclose the EAC team's findings to the Commission or ORS?
I don't think it was necessarily the EAC team's findings. It was simply here's a run, here's a scenario, and I believe they probably did a number of other iterations. The presentation that I recall being in October, I don't know that there weren't other iterations of that I did not attend. And it was a number of months later when we actually finished our negotiations with the consortium. So I don't think it was that the EC team said, look, this is what you've got to use, and management ignored that. That's not the case. They also came back with recommendations on exclusions of certain items. So everything in that EAC report was not presented to the Commission because there really wasn't a need to present all of that. That was used in negotiations with the consortium to come to a better result.
Was it shared with ORS?
I don't know if it's shared with ORS. I'm not sure if, as far as I understood, the work products that came out of it were probably drafts. I don't know if a final work product was shared with ORS. I know that ORS had access to the team that worked on it. I'm aware of the fact that ORS asked some questions about the 1.41 and the 1.15 PFs. So I believe that the ORS had access to the information.
But you're not sure?
I'm not 100% sure.
Bottom of page 4 over to 5, I think you were talking about, and this is of your summary. That I guess part of the reason management relied on the Westinghouse estimates was that it had the best information to develop or to determine a projected cost over the coming 4 to 5 year time period. Is that correct?
That's right.
Did it have an incentive to be completely forthright about that? As much as incentive as your EAC team?
The question of incentive with Westinghouse, at least at this point in time, was kind of an interesting one because, again, one of the reasons why we so zealously negotiated the October agreement, this predates that October agreement, was because we wanted to make sure that Westinghouse was incented to complete the units on time and give us information. In the EPC contract arrangement, at some point the contractor went closed book on things, meaning that up front the books were open and SC&G could have access to information. At some point the contractor goes closed book, particularly on the fixed and firm portions of it. So information that's in that closed book section, the utility people like me would complain to leadership at Westinghouse, look, there's some information that our teams need, with varying success at relinquishing that information. So Westinghouse did play things fairly close to the vest. So did Shaw, and so did CB&I.
Is that not a screaming red flag that maybe something was amiss?
It is not unusual for a contractor in an EPC arrangement, and SC&G has done a number of EPC arrangements, to go closed book. And once they go closed book, they don't have an incentive to give you the information that was in the after the open book portion. And once they go closed book, they don't give you the information. So it wasn't overly unusual, but SC&G did pursue, and I'd say the owners did pursue getting as much information as they could from the consortium.
Isn't it likely they had a pretty good idea that they were heading toward bankruptcy?
No, I don't think so. I don't believe that a company like Westinghouse would negotiate. Of course, at this point in time, this is the EAC, so this is prior to the October agreement. So you're talking about an assessment that the consortium actually gave to the owners in 2013. Owners said go back and don't just look at the submodules, look at the entirety of the project and give us. So they took about a year. And then came back and gave us their results of this year-long effort to come up with a new integrated project schedule.
Okay, I'm sorry.
So the IPS at that point in time, I don't know that there was any discussion or even thought about this putting Westinghouse at harm. In fact, the owners were focused on, is Westinghouse and CB&I, are they overreaching? Are they asking for too much? So that was another focus of the EAC team.
And as I recall, there was a lot of rework on modules having to be done at the site, wasn't there?
There was rework, and there was work that was started at a facility in Lake Charles, Louisiana, that was problematic. And the owners relented or allowed the consortium to send modules that were not finished and that they were actually completed at the site. That did two things. One, it freed up space at that facility down in Louisiana, and it allowed a more nuclear-savvy workforce to complete the construction on site.
Page 7 of your summary, end of the first paragraph, you say you didn't believe hiring an owner's engineer would be beneficial to the project. I think some parties have made an issue out of that. Even at that point, far along, it sounds like you still didn't believe that was a good idea.
Yeah, that's correct. I did not believe that bringing in an owner's engineer was necessary, and I did not believe that bringing in Bechtel as the owner's engineer was going to be a good idea for a couple of reasons. First of all, an owner's engineer would be required if the counterparty did not have experience. So let's say a school district was going to build a new school. The school board doesn't know a lot about construction. They enter into a contract to complete something. They may hire an owner's engineer to keep the contractor honest and give advice to the owners since they don't have that experience. In this case, SC&G had hired, at this point in time, I want to say 550 employees dedicated to the new nuclear plant, and probably 200 of those in oversight roles. Quality assurance, quality control, construction management, engineering, licensing. So look at it this way, the owners had essentially hired their own owner's engineering staff and had staffed it with very experienced people. Secondly, the only experience building under a new part of the Code of Federal Regulations called Part 52 was the Vogel project and the Summer project. That was the experience base. So bringing in anybody from outside as an owner's engineer, they would first have to come up to speed on all of the lessons that had been learned over the previous number of years of the project. And Bechtel didn't have any experience building under Part 52 either.
Okay. You talked about a lot more employees coming on site in that later time period. Did that pretty big increase in the number of employees on site? Did that increase efficiency?
No, in fact, increasing staffing, as I think I testified in 15 or 16 or both, was actually going to decrease efficiency. Now, that may sound counterintuitive. I understand that. But, if you're a lawyer and you've got 10 boxes of documents that have to be reviewed by Friday, and you assign 2 people to it, and it becomes obvious to you they're not going to get this review done on time, you can still get the review done on time by assigning 2 more lawyers. Now, the efficiency actually goes down. I've now got 4 people working on it, but they get it done on time. The rub is it'll cost you more money for 4 lawyers as opposed to 2 lawyers. So the efficiency will actually decrease when the staffing increases. So CB&I had recognized, and certainly Floor recognized, that they needed to increase the workforce in order to get the job done.
Only 10 boxes?
Well, it's just an example. I wasn't talking about this case.
I'm sure some of the folks in this case would like to have had just 10 boxes. Finally, at the end of your summary, you talk about that if bankruptcy had not happened, that you believe we would still be building today. I guess like they're still building at Vogel. Where would we be on costs if we were still building?
I think 2 things. Well, if the bankruptcy didn't happen, then the protection of the fixed price contract would still be there, such that the cost would not be much higher. You'd be talking only about owner's costs, not about the cost of the construction and the parts and the pieces. What Vogel did was they went to an owner-directed model, which is similar to what the EAC team did after the bankruptcy. They reviewed an owner-directed model. So my point here was that what really caused this cancellation, which is it's an awful outcome for everybody. There's no question about that. I don't believe that Westinghouse wanted to put themselves into bankruptcy. I don't think a corporation like that would take action to intentionally put themselves into bankruptcy. But the bankruptcy caused a loss of the fixed price protection. That really was what led to the cancellation of the project. And under the owner's directed model, the cost was going to be significantly higher to the customers.
It got them out from under what they were seeing
Certainly.
as a
Certainly. So
tremendously large burden.
So the company's position was that even with a higher cost, there was still a benefit to complete. But when we lost a partner, the company did then start to solicit help. So we looked for other partners, and other utilities around us seemed uninterested, and also made a pitch to get some federal support, and none of that federal support was forthcoming. So that was my point when saying that absent the bankruptcy and loss of that fixed price protection, I think we would still be building. Had we still had a partner, could have come up with another partner, gotten some federal guarantees, I think we would have probably completed 1 unit and left the second one to either complete later or mothball.
Ultimately, that would have ended up being a very expensive 1 unit.
The second option where there still is a bankruptcy but the partner stays in, I think it would have been more expensive than the fixed price option, certainly. Yeah, no question.
Thank you. That's all I have, Mr. Chairman.
Commissioner Hamilton.
Thank you, Mr. Chairman. How are you today?
I've had better years.
Let's go back to the Bechtel report and talking about...
Close to your mic, Commissioner.
Excuse me, sir. Your Atlanta attorney, Mr.
Winnick.
Winnick, we got it. As I understood his testimony, he was of the opinion that Bechtel had already been decided on by the partners before he was involved with it. In fact, I think he testified that they would not have been his first choice for the job that he was going to do. Bechtel was going to perform for the company. Do you have any information on this? I know earlier you said that he hired him.
I didn't hear what Mr. Winnick said. I didn't listen to any of the other testimony in this case. What I can tell you is, from my perspective, what happened. That is that, and I know Mr. Winnick was a little leery of a familial relationship between somebody at Santee Cooper and and somebody as an executive at Bechtel. I think it was a board member at Santee Cooper had some relationship with an executive at Bechtel. That aside, Bechtel is a company that certainly has the wherewithal to do this kind of an evaluation. That was not ever my issue. Westinghouse and Chicago Bridge and Iron were both going to view Bechtel as competitors. They were largely in the same lines of business. And I had a feeling that there was going to be some rub between Bechtel and Westinghouse and Bechtel and CB&I. And in the end, we found that to be the case. Bechtel repeatedly asked for documents. Santee Cooper and SC&G attempted to get documents. Westinghouse and CB&I, resisted and refused to give the documents. And then when they gave them, they were redacted, and we had to go back to try to get redactions removed. So the issue there was a case that I wasn't opposed to a third-party assessment. In fact, in 2014, I solicited a couple of other companies to try to do a third-party assessment. So I was never opposed to a third-party assessment. I think I've told you why I was not necessarily in favor of an owner's engineer. I think it would have added costs without any real benefit or any reason. And Bechtel certainly is a company that's big enough to do this kind of an assessment. Santee brought the prospect of Bechtel doing the assessment. I let the leadership at SC&G and Santee Cooper know that I was not in favor of Bechtel doing the assessment. So I was directed that the assessment was going to be done, and that it would be done. And so once I'm told what the goal is, I'm going to go out and try and accomplish the goal. And so from an operational perspective, I had assigned Jeff Archie to facilitate making sure that the assessment happened and that Bechtel had what they needed. And I also thought that it would be beneficial to try to get the support of CB&I and Westinghouse up front, which they pledged, but I guess that pledge was a little different than I saw it being. So they did pledge to support, but then, perhaps there was overreach by Bechtel on the part of what documents they wanted to see and what information they needed. Some of Westinghouse's points I could see, but again, they did resist the documentation. And I was also informed that it was going to be done by George Winnick's firm, and I was informed that it was going to be privileged. So my involvement was to try to ensure that from an operational perspective, the assessment could happen. Everything else was handled by the lawyers.
Thank you, Mr. Burns. Thank you, Mr. Chair.
Commissioner Whitfield.
Thank you, Mr. Chairman. Good morning, Mr. Byrne.
Good morning.
Mr. Byrne, it's certainly fair to say prior to August 1, 2017, I didn't think we'd ever have a meeting like this, a situation like this. I think you would agree to that.
I would agree to that.
Well, at this point, this hearing is largely about paths forward, but of course, in your case, we are looking in the rearview mirror a little bit. So I do want to take this brief opportunity we have with you to look in the rearview mirror just a little bit. Your description of not needing an owner's engineer that you had with Commissioner Elam and some with Commissioner Hamilton, I would certainly say, certainly speaking for myself and perhaps other commissioners, we viewed you prior to you being president of Generation and Transmission, you were chief nuclear officer. And you just now said on the stand that the company, the owners, had brought in several other engineers. And I felt like with your knowledge as a senior licensed reactor operator since the 80s, maybe from the NRC, that you were our engineer. I viewed Mr. Marsh and Mr. Addison both coming from an accounting background, but you were the nuclear expert in my opinion. And would you agree that we relied, of course, heavily on you for the technical side at these hearings?
Yes, certainly. There would be no question about that. I am an engineer. I have been a licensed operator since the 80s, early 80s actually. So there's no question that that I am a nuclear expert. I'm not necessarily a construction expert, which is one reason why the company went out and hired construction expertise.
But your expertise, having the long, extensive nuclear background, operator background you have, and the engineers you brought on the owners brought on that you just testified about, you still stand beside that today, even right now, that an owner's engineer in your mind was not necessary?
I do.
Okay. Let's move on to
one aspect of that perhaps I should point out is that Ellen Torres, who is our construction general manager,
yes, sir. I remember Mr. Torres.
probably had the most experience of anybody that I've seen in the construction field.
And he was involved with Unit 1, constructing it, right?
He was involved in construction of Unit 1 and had a background that lent itself very well to construction, 40-plus years of experience, and even today he's overseas constructing. So he put together a team that, in my mind, was exceptional. I think you've probably heard from a couple of those folks, Kyle Young, as an example, during this proceeding. Those folks were some of the best people that I could imagine. The skill level and the lessons that they learned under building under Part 52 was something that was going to take somebody else a long time to come up to speed with.
Well, you certainly testified to his abilities before, if I remember correctly, and we certainly remember him being on the stand in the original case and present thereafter. Let's move forward a little bit to the bankruptcy issues, and not to, you had a long exchange with Mr. Cox, I believe, about that, but you're saying that you didn't know until March 2017 when it became public, but weren't there public reports at least by the end of December or the latter part of 2016, at least media reports concerning the financial health of Westinghouse?
I don't think that there were reports before the impairment announcement from Toshiba. That impairment announcement from Toshiba was after Christmas in 2016. I don't remember the exact date, but I know it was after Christmas, 27th, 28th kind of time frame. So when Toshiba announced that there was an impairment against the U.S. nuclear construction projects, that was only Vogtle and VC Summer. So at that point, I think there was a lot of speculation in the media about what might happen from a bankruptcy perspective. And I think, at that point in time, the companies, I think Santee Cooper, SC&G, and even the owners over at Vogtle, and I think there are 4 owners over at Vogtle, really had no idea that this large impairment was going to take place. And of course, when they announced it, they didn't say how big the impairment was. All they said was there was going to be an impairment and that we will announce it at some point in the future. And I think they tabbed mid-February as the announcement date and missed that date. When they eventually announced the impairment, I think it was over $6 billion. That was just a staggering figure that I don't think anybody really foresaw coming. But once the Toshiba impairment announcement was made, right at the end of 2016, end of December of 2016, that's when some speculation started in the media about bankruptcy. And at that point in time, the owners had hired bankruptcy counsel and were preparing for that contingency as well.
There seems to be a little bit of which came first, the chicken or the egg scenario, the bankruptcy of Westinghouse or this commission approving your 2016 case, the fixed priced option that put all the burden on Westinghouse. There's some speculation, been a lot of discussion about whether that sent them down that path or were they already heading down that path anyway. And back to that, let's go back to that 2016. I want to kind of fast forward a little bit past the 2015 amendment that's been debated so much here, but up to the 2016 case, the fixed priced option case. is it fair to say, by your recollection, there were a lot of things that were promised in that proceeding, but is it fair to say that these three stick out in your mind? Number one, the company would not seek a rate increase until Unit 2 was online and in service. Would you agree on that?
Yeah, as I remember, that was one of the provisions of the agreement.
Yes, sir. The other is that the fixed price option contract, anything above $7.65 billion would not be borne by the ratepayers or the shareholders. Of course, under that arrangement, Westinghouse would be responsible for that. Is that correct?
I think that's
other than owner's costs.
Yeah, with one caveat that there may be a provision for allowable change orders, which certainly the company felt would be minimal.
And the third thing, this might be a little bit of contention the way you and I see this. The third thing I recall is that you came close on the stand here a little bit ago, but you didn't quite go far enough. I recall the company stating that it would finish the project with or without Westinghouse, because at that point there was some concern. We certainly didn't know what was about to happen, but there had been some questions. The questions, I think, mostly stemmed in that hearing from the parental guarantee of Toshiba, because CB&I was being allowed to, had been allowed to exit the project, and when they were allowed to exit, all of their liability and obligations went away. So that, I think, is what sparked some of that talk, or those questions, if you will, at the hearing. But would you not agree that the company led this commission to believe that it would finish the project with or without Westinghouse?
Well, I think that first off, the company had the wherewithal to finish the plants with or without Westinghouse. When you look at what happened in the bankruptcy, Westinghouse was still in business. And one of the things that the company was doing after the bankruptcy announcement was negotiating a services agreement with Westinghouse, such that it was going to be an owner-directed model, so the owners were now calling the shots. Westinghouse significantly reduced staffing levels in a support role, probably on a T&M basis, time and materials type basis.
Let me add one thing, with Fluor in the picture too. I'm sorry.
With Fluor in the picture.
With Fluor in the picture.
And I believe what I said was that Fluor would be the most likely candidate, not the only one, but given their experience on the site over a year plus, would certainly give them a leg up and experience at the site. So, and SC&G, I think, has been on record a number of times saying that they thought that Fluor was a good counterparty and had good past experience in EPC settings on big projects with Fluor. So, the Fluor issue was not a question. Intellectual property was a concern, and the company took actions to escrow that intellectual property, such that even if Westinghouse didn't exist, so there are different forms of bankruptcy. One of them would be that Westinghouse fails to exist, that the company could finish the plants on their own. So the company certainly had the wherewithal. It was the evaluation about what would be the cost to complete the units that really led to the decision to cancel. And
I believe two of the numbers that you all tossed out to us that day, August 1 of 2017, is you had 99% of the intellectual property in hand, 93% of the components were on site. Do those numbers sound about where you were at the time of abandonment?
I don't remember the exact numbers, but I wouldn't dispute that those are close. Yeah.
Let me ask you, now that we've talked about Westinghouse, 1 second about another factor in the company's decision. When did you learn of Santee Cooper's decision? We all know there was a board meeting. All this commission knows is there was some board meeting the day before that, the 31st, and then within hours, and I mean probably within 3 to 4 hours, the company, had issued a statement, and then it was the next day when you came in here. When did you learn that Santee was going to back out?
The exact date, I don't know, but it would have been sometime in July. And I believe that Mr. Carter communicated to the leadership at SCE&G or the SCANA that it's possible that his board could make a decision not to continue. And I believe Mr. Addison made the comment to Mr. Carter that you understand what that decision would do, and Mr. Carter said yes.
Prior to that, did you have any, of course, been a lot of speculation about Westinghouse status, but prior to that, even going back years before that, when it was publicly known that Santee Cooper was trying to sell a portion of their generation, did you have any reason way back then to ever doubt that they would not see this project through?
There are always questions about partners. Santee Cooper was all in up front, and actually was at the same time proposing building a coal plant in the PD. That coal plant was canceled.
Remember?
So it would seem logical to say that they would be more reliant on the nuclear plants. I think what changed for Santee was a couple of things. One, there was a change in the contract status with some upstate co-ops.
3 or 4 of them, right?
Yeah, I don't remember the number, but there was a number of co-ops in the upstate that were, over a period of time, were transitioning from Santee Cooper to somebody else. And so that I believe they were probably counting on load growth and other things making up that difference. So when the recession hit, that didn't happen. But even with that, the environmental regulations that were pending were going to be fairly significant and fairly onerous, and Santee Cooper would have benefited, I think, significantly from having nuclear generation as opposed to coal or gas generation, and they were fairly heavy on coal at the time. So, from an environmental perspective, I think that they were looking favorably at nuclear. When things changed with the Trump administration coming in and those environmental regulations and legislation looking like they weren't going to have as significant an impact, I think that probably changed Santee Cooper's thinking.
But you nor none of the executives at SC&G had any reason to doubt, is I guess what I'm asking you, that they would. What about I'm really quizzing the company's knowledge of Santee's status or concerns or worries.
Yeah. Well, my job was to build, so would want to have a viable partner. Santee Cooper had people dispatched to the site. We were acting certainly like a viable partner, and I believe had opportunities in the past to exit the project if they wanted to exit the project. But time after time, their board voted to continue to fund the project. They seemed very satisfied when the Duke issue was off the table, that SCE&G would buy 5%, and that seemed to satisfy them and their co-op partners. So, I think Santee Cooper, from my perspective, they had the opportunity to get out if they wanted to get out, and time after time reaffirmed their commitment to the project right up to the end.
2 more questions, Mr. Byrne. I realize you're kind of here on your own time, so to speak. Project Bluefin, what can you tell? I don't recall a whole lot hearing about that. What can you tell us about Project Bluefin? Everything else in here, seems like has come up before, but tell us about that.
So when Westinghouse and CB&I came to the owners and said, CB&I wants out, and Westinghouse said, and by the way, we want them out, that gave us the impetus to renegotiate the contract to get some more favorable terms. They had proposed Fluor as the construction manager, subcontracted to Westinghouse, which, from an SC&G perspective, thought that was a good thing. Had an opportunity to go up to Fluor's offices in Greenville with other folks from SC&G and St. T. Cooper and listened to the pitch from Fluor. And we said, well, when are you going to hit the ground running? And what they said was, technically we cannot be on site until the deal closes for Westinghouse to buy Stone & Webster from CB&I. And they anticipated that was going to be right near the end of the year, the end of 2015. And in fact, it closed, I think, December 31 of 2015. But before that, we were interested in them coming up to speed. And what they said that they wanted to do was get together with the construction folks from Southern, so Southern SCE&G construction management folks, along with Westinghouse and Fluor, and look at where are the opportunities to increase efficiency or make things better on this project. It involved hundreds of people. I think Kyle Young was probably the principal person from SC&G that was directly involved. Kyle relayed to me that he was extremely impressed with the resources that Fluor had put into this, and Westinghouse, and flying people in from all over the world, met here in Columbia. And they looked at 20 plus 25 different what they call work streams to try to make improvements. So that 2-month effort was before Fluor could officially show up at the site. So they went through that effort. Those 25 work streams ended up being functional area assessments, and those functional area assessments led to improvements on the site, things like streamlined work packages, faster in-processing of personnel, which helped Fluor to hire people, that kind of thing. So they were continuing to work on those functional area assessments, right through 2016, even up to the bankruptcy.
Well, I realized Fluor was entering into the Vogel project too under a similar, and I guess you had some synergies you were going to gain from both sites through Fluor. So basically, Project Bluefin was an assessment or preparation, if you will, in advance of Fluor coming on the site during a time period when they weren't allowed on the site. Is that correct?
Well, yeah. The fact that they weren't allowed on the site really shouldn't take away from the fact that Fluor was looking at bringing together significant resources to see what they could do to improve both projects. They called it 1x4. So there's 2 plants at Summer and 2 plants at Vogel, and they said, well, we want to operate it as if it's one big site. So that was their premise, was 1x4. Actually adopted earlier completion dates than the August dates that we brought to the commission. That team was working on June dates, June of 19 and June of 20 dates. But it was Westinghouse's opportunity to say, here's what's been going on. Here's what we don't like about how CB&I has been organized at the site and operating at the site. And it was SCE&G and Southern Company's opportunity to say, here are the things that we need. Here's what we need you to do. Here's what can we help you with. Here's what you can help us with. So it was a fairly significant effort, done off-site at hotels because they weren't allowed on site. But I think they would have gone through the effort had they been allowed on site as well.
Let's see. Last question. A lot's been said about the PF productivity factors, and there's been a lot of innuendo and speculation, this, that, and the other. Did you ever, I know you were pretty obviously a recognizable person out there, so you probably couldn't exactly sneak up on anybody or anything, but did you ever appear, or somebody maybe on your behalf appear at an odd hour or on site to see if any of these abuses or, lack of a better word, loafing was going on the job, or just sitting around waiting on? Did you ever do any of that yourself or have someone do that?
Certainly there were a number of times that I toured the site, able to make comments to people like Alan Torres or Kyle Young that, hey, I'm not seeing much work on this, and I think this, based on what I heard during the last monthly performance meeting, that's a key focus area. The N&D team, the owner's engineer, 200 plus people that I said that we've hired in and working on site, had goals on observations. So they would do hundreds of observations a month and have to document the observations. So that was there. And Westinghouse, to their credit, did commission an efficiency study for the craft workforce. and did that, I think it was twice in the 2016 timeframe. One of them may have been 2015, but I know there was at least one done in 2015.
What were the results of those by your owners, by your team, and by the Westinghouse? And had any results ever reported back?
Yeah. So from the efficiency study perspective, there were some things that, what you referred to as loafing. I wouldn't say that was the biggest problem there. I know it's been portrayed as you hire thousands of people and they just sit there and rest on their shovels or their spades. I think more the case was they got a work package and went to do work and found a design issue that was hamstringing the superintendents and the supervisors and getting the craft out to work. When CB&I was there, that was causing more problems, I think, than anything else. Fluor recognized that I can take that craft and I can redirect them to another work front, and so they would move them somewhere else. So the emphasis became we need to increase the standby work packages or the backlog of work packages. So that's one thing that came out of all of these observations. The efficiency studies that were done, they came up with things like where to locate the break areas, cell phone abuse on site, and Fluor had to make some unfortunate decisions to not allow people on the site to have the cell phones. So that was a bit of a morale hit for a little while. But so there were things like that: break time, start time, stagger the start time. So the efficiency studies were doing things like that. The bigger picture things were things that certainly the owners were aware of. They were design-related issues largely, or when you're doing just-in-time construction and the procurement system is based on that, and things don't happen on time, then the procurement system needs to be changed. And that was recognized by Fluor as well, so they went to a min-max rather than a just-in-time. And when submodules don't show up and they're supposed to be put in the excavation, it changes your plan. So getting the submodules completed was really a big deal.
Thank you, Mr. Byrne. Mr. Chairman, that's all I have.
Thank you, Commissioners. Commissioner Irvin.
Thank you, Mr. Chairman. Mr. Byrne, you mentioned earlier testimony about performance bonds that you had in place, and I had asked earlier witnesses why we didn't have more of those protections for the project in the event of a bankruptcy. Can you address that, please?
I'm afraid I'm probably not going to be able to address it. I was not in the financial end of the company, so the performance bonding and those kind of things were done that were financial protections in the contract. And the triggering of those was done on, I think it was the bond rating of Toshiba. And so there was a credit department in the company that was monitoring those kind of things. During the 2014 EAC negotiations with the consortium, there was an attempt to change some of the portions or provisions of the contract. Westinghouse was standing by the contract at that point in time. In 2015, when the EPC was renegotiated, we came up with the amendment to the EPC in October of 2015. There was a lot of discussion about things like bonding, but I think it was felt that the increase in LDs, so the focus really was not on bankruptcy at that point in time, it was get the project finished. So the increase in liquidated damages and bonus provision, where you had about $1 billion incentive for Westinghouse to finish the plants, was viewed as more important. And then the parental guarantee, if you go from fixed and firm of 57% now to 100% of the project is in the fixed and firm category, and your parental guarantee is 25% of that fixed and firm number, you've now significantly increased the parental guarantee. So, those were the focuses during the amendment period is getting some of those other protections and implementing the intellectual property provisions. So,
But in hindsight,
beyond that, I can't help you.
we would have been better served if we'd had a performance bond in place early on, would we not?
I don't know enough about performance bonds to tell you who benefits necessarily from the performance bond.
Well, the ratepayers would have benefited.
Well, my understanding of the performance bonding was that it would have helped pay sub-vendors who were owed money. So again, I'm not sure if there may be different types of performance bonds, but I'm not an expert in that area.
Well, the truth is that SC&G would never have undertaken these projects unless they could shift the risk to the ratepayers through the Baseload Review Act, because they would never have taken on this risk without some kind of guarantee that it could be financed. Correct?
I think Mr. Marsh is on record in testimony a couple of times as saying that the company would not have endeavored to build these plants without the Baseload Review Act.
Correct.
Yeah.
And that's a fact. So would you agree that there were numerous mistakes made back in 2008 when you made the choice to go with the Westinghouse AP 1000 reactors, which had never been put into a project before, and they had numerous design issues. In fact, there were 17 formal revisions before the design was finalized. You knew that, didn't you?
I don't think I would agree with the characterization that mistakes were made in selecting the AP 1000 unit. The process of the design certification, it was not unusual for the Nuclear Regulatory Commission to, particularly over time, the premise is you have a certified design, you can put it on the shelf. Well, things will change over time, so that certified design has to be addressed. One of the biggest things that changed was aircraft impact after the September 11th of 2001 impact on the World Trade Center. That was a fairly significant change. So some of those revisions were fairly minor and some of them were fairly major, but caused by events generally in the nuclear industry that required assessment.
And in fact, the Nuclear Regulatory Commission didn't even have a process in place to license this reactor until later, right? In fact, they'd never licensed one in this country, had they?
When the application was submitted, that is the case. Now, the Vogtle reactors did get the license a little bit ahead of the VC Summer reactors.
Ours did not.
My point there was that the Vogtle reactors and the Summer reactors were the same design. They got their license a little bit ahead of us, so they were licensed for a short period of time when the Summer units were not. But any of the designs that SCE&G was going to build under Part 52 would have had to have gone through the design certification process. The other designs considered were not as far along as Westinghouse in that NRC process, the licensing process. And if you look back at Fukushima, one of the issues that the company had, or the concerns the company had back in 2008, was a nuclear event somewhere in the world would have an impact on construction. A lot like TMI had an impact on VC Summer Unit Number 1. So Fukushima happens, which is, from my perspective, my worst fear is realized in 2011. And to be honest, that had a less of an impact than I anticipated it would have. And when the NRC evaluated that situation, they actually recommended continuing the licensing of the passive designs, but did not recommend continuing the licensing of active designs, like the AREVA unit that we had been considering. So I think the selection process of the AP 1000 actually was the best decision the company could have made on nuclear.
But you really couldn't have made it financially work without the federal subsidies either, could you? The numbers wouldn't work.
I'm not sure that the number, again, I'm not a financial expert. There were a couple of different kinds of financial subsidies. The company only took advantage of one of those, or had intended to take advantage of one of those, and that was the production tax credits. Loan guarantees that were a big part of that Energy Policy Act 2005, the company did not take advantage of those.
But when those modules started coming back from Louisiana and they weren't usable, they couldn't be, they essentially had to abandon that process and begin to form them on site. Is that what happened?
The facility in Louisiana was actually built specifically to make submodules for these reactors, so it was a bit of a surprise that they struggled so much. they were, because of some quality and training and NRC issues, they were not delivering. So those were plugging up the works, if you will. So if you're looking at kind of an assembly line going through the process and things aren't coming out the tail end, then you can't put things in the front end. So to ease congestion at that facility, what the consortium asked for was permission to move some of those to the sites. And so they asked us if they could move uncomplete submodules to the VC Summer site and complete them there at the site. So we
I guess my question really goes to the point of you had warning signs early on in the project, and why didn't somebody say, well, maybe we'd be better off with a gas-fired plant there if we're going to have all these problems? Can't even get the modules in a working order. Was that ever considered?
You have to go back to what you knew and when you knew it, and in those time frames, the price of gas was still relatively high. When these plants were licensed and when the company applied to this commission to build those plants, the previous couple of builds had been natural gas, so the company was a little heavier slanted on gas. The company was looking forward to retiring some of its older coal plants and trying to get the energy portfolio more balanced by fuel source. So from that perspective, the nuclear was the right way to go. With gas prices still high, that generation was going to be relatively expensive. And so it wasn't until the price of gas fell and stayed low that fracking really came to the fore, and now all of a sudden it's an unlimited gas supply. The rules and regulations on CO2 emissions, the gas plants do still emit CO2. And I believe that based on the decisions at the time, the consortium was working very hard to get the modules fixed. The modules that were being assembled here at the site or in Jenkinsville at the site, those were being fabricated with good quality. So while there were delays there, when CB&I came in, to their credit, they did look at diversifying the supply chain, and in large measure, that diversification worked out very well. So, in 2016, I think as I testified, I thought the prospect for this project was really very good. In fact, I would say that in 2016, I felt good about this project. Good enough to the point where I was offered a CEO position at another utility for double the pay that I get now, and I turned it down to stay here because I wanted to finish these projects.
Thank you, sir. Those are the questions I have.
Commissioner Williams.
Thank you, Mr. Chairman. Thank you, sir, for being here today. Well, do you wish you would have taken that CEO gig now?
I will tell you my wife does.
Hindsight is 20/20. Well, sir, I just want to run through a couple of questions with you as we're drawing close to the end of this proceeding. Who do you think should be ultimately held responsible for the failure of this project?
Yeah, good question. I think that responsibility goes in a lot of places in a lot of different directions. As I said in this summary of testimony, and I said before, were it not for the bankruptcy at Westinghouse, I believe we would still be building the plants today. I think that would have been the best outcome for the state, for the customers, and for the company. So really, it was the bankruptcy at Westinghouse, and while we did lose our partner at Santee Cooper, that was really because of the loss of this fixed price option and the bankruptcy at Westinghouse. So I believe that they would have stayed in had the bankruptcy not happened. So, from my perspective, from the perspective of the builder, I would desperately still like to be building these plants. And so it was that bankruptcy decision and not honoring the fixed price contract and the loss of that protection that really forced the cancellation of this project.
I understand. Thank you, sir. Well, who's next after Westinghouse? Then whose shoulder should the blame fall on?
The short answer is I'm not sure after that. I think, below that, it's clear that, if we would still be building, if Westinghouse didn't declare bankruptcy, then you'd have to go back to, well, was the decision to build nuclear not a good decision? I still think the decision to build nuclear was a good decision. So, whether that's the company, our partner, Santee Cooper, or anybody else that's been involved in the process, my perspective is it's probably equal. But I don't know that I would necessarily point to one specific entity and say, you didn't do your job and that's why this project got canceled. The only thing I could clearly point to say, that's what forced cancellation. Really, that was the bankruptcy on Westinghouse's part.
Okay, sir. The way I understand ORS's position is that the company misrepresented material facts and quite possibly could have been deceitful with information that they did not share with the ORS. Opposite to that position, Kim Brown testified that ORS knew essentially everything that the company knew. Do you have any opinion about who knew what when it comes to the ORS?
Well, my interactions with ORS were fairly limited. I probably only addressed Office of Regulatory Staff maybe half a dozen times, and that was generally at their offices in Columbia or company headquarters in Casey. So my understanding of our relationship with the Office of Regulatory Staff came from my staff, and my staff would let me know that they would meet regularly with the Office of Regulatory Staff, that the Office of Regulatory Staff had access to the site, that I think they actually had a trailer out there for a while. I don't know if that trailer ever went away. But both the financial end of the auditing end of ORS and the construction end of ORS had access to the information that our team had and had access to our people. And then at some point in time, the Office of Regulatory Staff expressed a desire to talk more frequently with the constructors. And so they then started meeting on, I think, either a monthly or quarterly basis with Westinghouse and CB&I, and then just Westinghouse when CB&I went away from the project and talked to Fluor. So, they had access to much of the information that our team had.
So is it your testimony that the company clearly and transparently communicated or expressed all the issues associated with building the units 2 and 3?
I believe that the company did clearly communicate all of those issues. I know that the Bechtel report has been raised in this case as maybe the example of something that was not shared. So, from my perspective, I was directed to do that assessment and was told that it was being done by a law firm and was privileged. And I was counseled not to even talk to my team much about it. So there were folks that worked for me at the site that knew relatively little about that whole process.
Who counseled you not to talk to your team about it?
The general counsel.
The general counsel that works for SC DN?
SCANA's general counsel.
SCANA, okay. In your summary on page 3, starting at line 15, or I guess starting at the second sentence on line 14, and I'm quoting here, in testimony submitted to the commission, I expressly identified that the schedules can and almost certainly will change, period. I also testified that the consortium was not achieving the productivity factor that it used in its schedule estimate, and it would be a substantial challenge to achieve this PF, period. That was your testimony to the commission at that time, right?
That's correct.
Okay. When you gave that testimony, was it your intent to indicate to this commission all of the issues that you knew or the problems that you knew were ongoing at the site? I mean, when you gave that testimony, was the Bechtel report or the numbers from the internal EAC team, were those the challenges that you were referring to?
No, at this point in time, keep in mind that the Bechtel report hadn't been issued. They hadn't even done their assessment. The challenges that I was referring to were challenges that the consortium was facing, and keep in mind it's still a consortium at this point in time, CB&I is still in, and that they had set themselves a challenge on performance factor or PF. The original premise was that the performance factor would be 1. They did attain a performance factor of 1 early on in the project on a lot of the civil and earth-moving work, but had not been achieving that PF of 1. The owners had addressed that with the consortium fairly frankly, and the consortium had made some pledges to try to improve it, but that they changed in their 2014 estimate to complete from a PF of 1 to a 1.15. So they set themselves a less challenging PF, but still were not making that less challenging PF. And I was letting the commission know that I doubted that they were ever going to make it. Now, that doesn't mean they couldn't complete the plant. So as we talked about a little earlier, if you've got a job to do and you're not very efficient at the job, you can apply more resources to it, still get it done on time, and that will actually make it less efficient. So you're not having more people working to get the same amount of work done. So the PF will actually get worse, but you can still get the job done on time. So if they weren't able to achieve the PF, to get the work done on time would require more resources. That would mean that the company would have to come back in with another petition for potentially more money.
Did you tell the commission that at the time?
I think I said that failure to, I'm paraphrasing here, but failure to hit the PFs would have an impact on schedule and cost.
And the reason I'm going down this line of questioning, Mr. Burns, is that the ratepayers are, it's been said a million times, the ratepayers are paying for a hole in the ground, for rusted steel, for a failed project that's never going to produce a kilowatt of energy. And that has the folks in District 6 highly upset, and quite frankly, every customer who has had to pay for this failed project. So while I understand that your opinion, your testimony is that there's a lot of blame to go around, there are folks that have blamed this commission. There are folks that have blamed the ORS. There's folks that have blamed SCE&G. And I just want to make sure I understand your position here, that the commission, and maybe let me ask you the question, do you think this commission bears any of the blame for this failed project?
The short answer is I'm not sure from a blame perspective that I would point the finger necessarily at this commission. I can understand how other people might, but I don't know that I would.
Well, let me ask you this. How do you understand that other people might? What makes you say that?
Well, as you said, that there are people in District 6 that are blaming this commission. So, without knowing the workings of the commission, it would be easy to point a finger and say this must be your fault. So, and there are people. By the same token, there are people that would look at the plant failed. SC&G was the one that petitioned for the plant. They must be to blame. So I can understand the knee-jerk reactions that people have and the desire to affix blame to it. I get that. I understand that. And there's nobody more disappointed than me that we're not still building these plants. And I would love to be able to build the plants and have the ratepayers have something to show for what they spent.
Understood. Now, there was a witness yesterday that testified that the FBI just showed up at her house to ask her some questions about this plant. Do you think that anyone broke the law in developing or performing, or in let me rephrase the question. Do you know, or do you believe that anyone broke the law in regards to this new nuclear development project?
Yeah, I don't know of of anybody on the owner's side that broke the law. I don't know enough about what's been going on the contractor side since I left the company to know if anything has come up there.
Thank you for your testimony, sir.
Thank you. Any other questions? Commissioner Howard.
Good afternoon, Mr. Byrne.
Afternoon.
Several questions. If you knew what you knew now, had to make the decision to go with nuclear generation, would you still make the same decision?
I think when you say if I knew what I knew now, we've canceled the plant, then I think I'd probably be considered a fool.
I'm giving you a mulligan also.
Okay. I think the decision to build nuclear, based on the information we knew then, was the right decision. I thought that the selection of Westinghouse as the reactor supplier was the right decision. Obviously you learn, and with hindsight, there are things that you'd like to see done differently. I will tell you that my life would have been a whole lot easier had we just made a decision to build a natural gas plant or 2 natural gas plants, which is what it would have taken. So, I would have been incentivized the same way, and we would not have had near the amount of headaches that we would have had with building nuclear. But, based on the information we had back in the 2006, 7, 8 timeframe, that wasn't the right decision to make. So, in hindsight, would I wish we would have done that? Sure, after this cancellation decision's been made. But, you had to make decisions you have to make with the information you have at the time.
What do you feel the future is of nuclear generation in the United States today? Where's nuclear generation?
I think nuclear generation, you're going to see decline. I think that there are obviously with 100-ish plants that have been operating. You've seen some shutdown announcements from a couple of years ago. I think that as some of those plants get to the age where a decision on relicensing would have to take place, they may make the decision not to relicense, particularly in competitive markets. So I think you'll see the number of nuclear plants decrease. I think the Vogtle plants will come online. I think that they'll be good operators. The Chinese plants have come online. 3 of the 4 are commercial, so they're operating at 100%. And the 4th one should come online sometime early next year. So, the future of nuclear worldwide, I think, is good. The future of nuclear in this country, I think, is not as rosy. And I think that, if anything, it'll be small modular reactors that may sort of fill niche roles in this country.
Would you still do an EPC contract?
Yeah, I think, again, you have to go back to the information you have and what you know, and from the 70s and the 80s when companies made decisions to build and acted as their own general contractor, that did not work out very well for them. So I still think an EPC arrangement is probably the best way to go.
I'm hesitant to do this, but I will. Following up on Commissioner Williams, when he asked you if the PSC had any blame, did you blame the PSC? Are you aware of the fact that virtually every one of the cost recovery hearings was a result of a settlement between the utility and ORS?
Yeah, I think that all of the hearings, bar perhaps the first one, involved a settlement hearing between the utility, ORS, and one or more of the interveners.
Thank you for testimony. Thank you.
Sir.
Commissioner Elam.
One question that occurred from something you said, I think you were talking to Commissioner Whitfield. You talked about a point where natural gas prices got low and stayed low. When was that?
I would say that was a few years ago. So, if you go back to the company made decisions to build nuclear based on an integrated resource plan. Integrated resource plan, as you know, is filed with the Commission every year, and it's a 15-year forward look. In that 2004-5 timeframe, it called for baseload generation in the 2015 timeframe. So that was the impetus to look to build something. Started to look at things like coal plants and that kind of thing. it was obvious that the regulations were going to force coal off the table from SC&G's perspective. 2005 was Katrina. And if you remember, the gas price spikes after Katrina, they jumped over $20 a decatherm, settled back down to something more reasonable, but were still very expensive, far higher than prior to Katrina. So that was kind of the backdrop around the decision being made to not to build gas, but to build nuclear.
I understand that. I just was looking.
Yeah, so if you fast forward a couple of years, fracking comes to the fore. And I know that fracking is still perhaps a controversial topic, but it certainly appears now that there is plenty of natural gas out there for the foreseeable future. So provided something doesn't derail fracking, then I think the gas prices, their current, they drop probably to in the $2.50 a decatherm range in the probably 14, 15, 16 time frame. I think they've jumped up a little bit now again to the $4 range, but they certainly came down, and I think all of the prognosticators on natural gas would say that it's going to be low for the foreseeable future.
You saying that they weren't low around 2012, 2013?
They were certainly lower than when we came to the commission in 2008. I don't know that I would classify them as low, but as I think you're aware, the company did, at a number of points along the way, do another study to say, compared to natural gas, would it be beneficial to abandon the plants here and pick up a natural gas strategy? And that was not the case up until the abandonment.
And those assessments would have depended on whatever input gas prices Dr. Lynch would have used.
That's correct.
Okay. Thank you.
Thank you. You have a question?
I do have one follow-up.
Commissioner Whitfield.
Mr. Byrne, we've asked you from the commissioner several speculative questions. With SC&G, and of course you're not there anymore, with SC&G pursuing the tax write-off and under abandonment and basically walking away and convincing the IRS that it's walking away. And you've made the statement several times you wish you were still building the nuclear plants. What's to stop Santee Cooper in the future, or a potential successor to Santee Cooper, from coming back in and finishing one of the units?
Technically, there isn't anything that would stop somebody from finishing one or both of the units. But as you point out, I'm not with the company longer, so I don't know what if any discussions have taken place between the company and Santee relative to the sites. But technically, there's nothing to say that the plants couldn't yet be finished.
Thank you. That's all I have, Mr. Chair.
Thank you. Mr. Balls, any redirect?
Very, very brief redirect.
Okay, and before you do that, I want to make sure we had a question on the errata sheets. You entered all those with the testimony. We just got one from, what was it, the August the 14th one, from the August the 14th deposition.
No, the errata sheet that we submitted this morning was for the October 23rd or whatever it was deposition. So I believe that the errata sheet for the August deposition was submitted with the transcript.
It was submitted this morning. So Ms. Wheat, she's doing a great job keeping us on track, and she pointed out that issue to me. We quickly remediated that, so you have the complete errata sheets for both volumes.
And so that everyone's clear, the errata sheets that were filed are all just minor transcription errors. There are no substantive changes in the testimony.
Okay, so do you consider both errata sheets as part of the original Exhibit 161 with the exhibits to Mr. Burns' deposition?
Well, I think the actual errata sheet should go with the pre-filed testimony itself.
Okay, you can.
So we're good with that? Okay.
That's good.
Okay.
Thank you, Mr. Chairman. Mr. Byrne, do you have your summary in front of you?
I do.
Can you turn to page 7, line 12 of your summary? I believe there is an error in the date with respect to the Bechtel report, and I'd ask you if you agree with me and would want to correct that.
Yes. I looked at this a dozen times, and I don't know why I didn't catch that. That date should be, on line 12, should be 2015, not 2016.
Thank you, Mr. Byrne. Commissioner Williams asked you a question about the privileged nature of the Bechtel report, and you referred to the general counsel of SCANA. Who was the general counsel at the time?
That was Ron Lindsay.
Do you have before you exhibits 164 and 165 that Mr. Cox showed you? They are the DRB order and then the owner's statement of issues remaining in position on those issues?
Yes, I do.
Okay, I want to direct your attention to the last paragraph of Exhibit 164, which is the order, which is paragraph 14. And that reads in part, in the event the parties have been unable to reach a full and final resolution of this dispute, I'm paraphrasing, on or before November 3rd, 2016, they shall advise the DRB in writing on November 3rd, 2016 of the issues remaining in the parties' respective positions. Do you see that?
I do.
And then it goes on to say, in this event, the DRB shall conduct a further hearing on November 9th, 2016 in Atlanta, and shall on or before November 30, 2016 make its determination and issue its written report. Do you see that?
I do.
And do you know or do you have any recollection as to whether there was a subsequent hearing later in November of 2016?
There was a subsequent hearing.
Okay. And I want to show you a press release that the company issued on October 3rd, 2016. Mr. Chairman, may I approach the witness? Mr. Byrne, you've been handed what I would like to mark as the next hearing exhibit, Mr. Chairman.
It will be entered as Exhibit 166.
And is this the October 3rd, 2016 press release?
It is.
Okay. Can you, Dan, can you blow that up? On October 3rd, 2016, the company issued a press release announcing the DRB decision that has been marked as Exhibit 164. Is that correct?
That's correct.
And in the press release, was there an indication that there would be, if the parties couldn't agree on issues respecting that decision, that a further hearing would take place?
It certainly does, yes.
Okay. I want to hand you, if I may, Mr. Chairman, approach the witness again. Been handed a document that I would like to have marked as the next hearing exhibit, Mr. Chairman.
It will be Exhibit 167.
Mr. Byrne, do you recognize Exhibit 167 as the final order issued by the DRB on December 2nd, 2016?
Yeah, I think they term it final report, but yes, final order.
And finally, if I may, Mr. Chairman, I'd like to approach the witness with one more document. I'm sorry, what number did we mark this? Did we? Okay, I'd ask that the document that has been handed to the witness be marked as the next hearing exhibit.
It'll be entered as Exhibit 168.
Mr. Byrne, do you recognize Exhibit 168 as a press release issued by the company on December 5th, 2016, announcing the DRB's final report on December 2nd, 2016?
I do.
Mr. Chairman, those are all the questions I have.
Thank you. Any recross?
Very briefly, Mr. Chair.
Y'all keep pushing. We can get to 200 on this thing if you need.
Mr. Byrne, the press release dated October 3rd that Mr. Balzer showed you, Exhibit 166, that document does not reveal that the DRB had determined that there would be no true-up. Is that correct?
I believe that the language that you just stated is not in here, but as I believe the language does indicate that the parties were ordered to go back and work to come to an agreement, and if no agreement would be reached, then a further hearing would be held.
That's an agreement on developing a construction milestone schedule, correct?
Well, I think yes, certainly the construction milestone payment schedule and other things in the original order.
Isn't it true, Mr. Byrne, that on the September 30th order by the DRB concluded that there would be no true-up on the payments that had been paid to that date by the owners?
It was certainly in that order, and I think that there were a number of provisions of that order that were yet contentious between the parties that they were going to try and resolve with the construction milestone payment schedule. So, as I recall it, the things were not final until the final order.
There was nothing prohibiting SC&G from revealing that order to the Commission in the October 2016 hearing, correct?
Yeah, I think that certainly the press release was issued, and my guess is that there was also other information released on or around this October 3rd press release that outlined what the Dispute Resolution Board had done.
No further questions.
Thank you.
Mr. Chairman, just for to make sure the record's clear, I did want that last exhibit entered into the record as the exhibit. I think all three. I asked that they be marked, but I'm not sure.
I think we got them all entered into the record.
Thank you.
If
Yes,
we
sir.
could just ask if Mr. Balzer would provide copies to the other parties. We don't have any of those.
Yep. I apologize for not having enough copies. We were scrambling after Mr. Cox's questioning of the witness to get these documents so that the record could be more complete, and we will get those to all the parties promptly.
Okay, is that good? Okay, so got 168. So when and if we ever finish this, and anybody wants to read these documents, there are 3 or 4 of y'all who really have an affinity for the mic. I'm going to let y'all read them. But right now we're going to take a break until about 1:38, and we'll be back. What?
Mr. Chairman, may Mr. Byrne be excused?
I thought he was having so much fun he don't want to stay. Mr. Byrne, thank you for being here. Sorry I overlooked you. I was anxious.
Thank you.
And you are excused.
Thank you.